screen, you should see a rectangle with an arrow pointing up on the bottom bar underneath all of your faces. If you click on that, it should be able to show you 3 options of what you want to showcase.
Oh boy. All right, let's see if I can pick the right thing here. How's that look?
Perfect. It's loading in now. Perfect.
Now we'll see if I can walk and chew gum at the same time.
All right, and just as a little intro, today we're here with Leonce with Angus and Terry, and it is our CMU, and we're going to be talking about elections today.
Well, thanks so much for having us, everybody, today. It's great to see everyone. Yeah, again, I'm Lance Stewart with Angus and Terry. I'm a partner, for those of you who don't know me. And we'll get into elections in a moment, but just some background about our office. We represent homeowners associations. That's all we do. That's all we have done for 35 years. We represent about 1,000 different communities across California, Ohio, and Florida. We represent both for general counsel purposes and, of course, the construction defect matters. If anybody needs a proposal, just let me know. This presentation is not itself legal advice and should not be distributed without our consent. It's meant to be general informational purposes, as we'll talk about. The law changes all the time, particularly with regard to elections, and we don't want anyone relying on outdated information. Any HOA that you guys are handling that's a current client of ours can certainly reach out for a specific analysis of their situation. Anybody that needs counsel, we're happy to help out them as well. That's our disclaimer. That's me. We're talking about elections. Before we dive in, elections are extremely complicated. To start with, when I say the word election, I don't just mean board elections. That's the thing we tend to think about. That's the most common scenario, but I'm talking about any time the members of an HOA, the homeowners of an HOA, need to cast a vote. There's a handful of things, as we're about to talk about, where the law says those decisions can't be made by the board. They have to be made by the members. They have to be made by the homeowners. And for those situations, there's very specific laws regarding how they have to be handled. When you hear me use the word elections, don't just think board elections, think membership votes in general. HOA elections have always been complicated under California law. They got a lot more so in 2020 with the passage of Senate Bill 323. And they got a little bit more so in 2022 when the legislature realized they had goofed on acclamation, as we'll talk about later on, and made the procedure even more complicated. We're going to go through all those things, but the main thing to take away at this point is HOA election law is highly technical. It always has been. It's very easy for there to be a technical error somewhere along the way, and it's very easy for a homeowner to bring a legal challenge. And these days, we all know just about every community has a squeaky wheel, if not more. Somebody with an axe to grind who's looking for a basis to sort of stick it to the HOA. One great tool for them to use to do that is the Open Meeting Act, and another one is election violations. Don't be shy about asking for help. Reach out to us in the beginning, reach out to counsel in the beginning. We can set you on the right path. And certainly if things do go sideways, you have a challenge, we're happy to help out in that context as well. But don't be shy about asking for help. And I generally say to you guys anyway, if you're not sure whether something is a legal issue, give me a call. I'll help you out. This right here is the list of the major membership votes, the major issues that need to be handled under the Davis-Sterling Act through the procedure we'll be talking about, the decisions that can't be made by the board, and membership votes that require an inspector of elections. The big issue that we all deal with all the time is board elections, determining who's going to sit on the board or potential recalls, removals of board directors. That's a big one. Another very common membership vote is assessments that require a determination by the members. Usually what we're talking about is a special assessment requiring a membership vote. The process we're going to go through is applied to special assessments as well. Amending the governing documents, that requires a membership vote, usually. A less common scenario that comes up is if there's going to be a new grant of exclusive use of the common area. We don't see that issue a whole lot. It does come up, and the idea is We're going to take this part of the common area that had belonged to everyone, and we're going to take it away from everyone and give it to just this one person for their exclusive use. It didn't start out that way. We're going to change it. That's one that requires a membership vote. And the governing documents will sometimes say that certain other things must be determined by the members as well. For all these things, you're going to need to apply the process that we're about to go through, and you're going to need to have an inspector of elections to oversee things. One of the big changes that came about with SB 323 in 2020 is the legislature said to all the HOAs throughout the land, change your election rules, do it right now. And we all sort of had to scramble around in a hurry to change everybody's election rules overnight. We still see some HOAs that haven't gotten around to this yet. Take a look at your accounts. If you have any HOAs that haven't updated their election rules since 2020, they're probably in violation of the law. They need to get that fixed, reach out to us, reach out to council, get it addressed. Because there was a massive overhaul in how HOA elections are run, and part of that overhaul was to say each HOA needs to have election rules that say specific things. Those election rules need to be adopted at least 90 days before the next membership vote. They need to provide a lot of detail regarding the duties and responsibilities of the inspector of elections. They need to address handling of ballots. They need to address announcing the outcome of the membership vote. And they need to address handling election materials after the membership vote. And we'll come back to that topic later on, and we'll talk about some of these things in more detail anyway. But that's a critical piece. Make sure all your HOAs have newfangled election rules following SB 323. The election timeline looks like this. Now, way back in the day, when HOAs had to hold membership votes, everybody got together in the clubhouse and raised their hand. We haven't done that in a long time. More recently, until a few years ago, the process was essentially a secret written ballot. We'll talk later on about the secret written ballot portion of it, but the idea was you send out a ballot packet to everyone, you give them 30 days to vote, and at the end of that 30 days, you tabulate the votes. When SB 323 was passed in 2020, it extended that timeline. It said a few things. Well, first of all, we want to have the call for candidates period always be at least 30 days. And in addition, we want to send out a pre-ballot notice 30 days before the ballots go out. So what had been a 30-day process then became sort of a 90-plus day process. Then in 2022, the legislature realized they had screwed things up with acclamation, and I'll talk about that more in a moment. And so they came up with this much longer process, so that really we need to be thinking about membership votes, particularly board elections, as sort of a 6-month process. If you haven't done this already, I'm not sure what Paul's protocol is, but take a look at all your accounts. Figure out when they are used to holding board elections and when the bylaws say they're supposed to hold board elections, and count back 6 or 7 months. That's when you need to start thinking about the board election process. Now, this particular process, some of these things don't apply to other votes. A lot of this is specific to board elections, so that's what you need to be thinking about right now. The process can take up to 150, 180 days. What happened was, until SB 323, the idea of an election by acclamation wasn't really said in any statute, but there were court decisions where we all sort of agreed that acclamation was something HOAs could do. The legislature changed the law in 2020 with SB 323 and made it seem like most HOAs actually can't do elections by acclamation. So then in 2022, they decided to clarify that. So now we can do it again, but there's a much more complicated process, and it looks like this. Now the call for, if you're going to do an election by acclamation, the call for candidates needs to go out 90 days before the nomination deadline. And it needs to include specific verbiage. It needs to say specific things, basically telling members that we're contemplating an election by acclamation. Then 7 to 30 days before the actual nomination deadline, a second notice needs to go out to members, reminding them of the deadline to submit their nominations, and reminding them again with specific verbiage that acclamation is a possibility. Then at the end of all that, you have the actual nomination deadline, the close of nominations. Now, at that moment in time, and I'll talk more about acclamation itself in a moment, but at that moment in time, we can see where we are and figure out if acclamation is a possibility. And basically the question is, we've got X number of open slots on the board, X number of seats that are up for election. Do we have more candidates than we do open seats? If it's the same number, or if it's fewer candidates than open seats, then you can potentially do an election by acclamation and save everybody the trouble of actually voting. If at that point you're not able to do an election by acclamation, you have more candidates than you do open seats, then you proceed with the rest of this process, which is 30 days before the ballots go out, you send a pre-ballot notice to the members saying an election is coming soon. Then 30 days before the actual election, you send out the ballot packet. Then 30 days later, you actually hold the election. And 15 days after the actual election, you post a notice of the results. A couple things to highlight. We're bouncing around topics a little bit, but the whole business of call for candidates, nominations, that obviously does not apply to anything other than board elections, okay? And the legislature also recently clarified the idea of a pre-ballot notice does not need to be done for anything other than board elections. So you're dealing with special assessments, amending the governing documents, exclusive use of the common area. You don't need to worry about candidates. You don't need to worry about the pre-ballot notice. Okay, I've been saying elections by acclamation a lot. Let me explain that a little bit more. The idea is we've got X number of seats. We've got fewer candidates than we do seats. We've got the same number of candidates than we do seats. Why bother counting votes when we know what the outcome is going to be? What the legislature clarified in 2022 is that you can do that as long as you've met certain requirements. A big one is that you have to hold a board election by membership ballot, by membership vote, at least once every 4 years. So if you haven't held a board election by membership ballot in the last 3 years, then you can't do an election by acclamation. Yes, Melanie?
That was what I was going to clarify. It's 3 years that you can do acclamation, and then you're saying the 4th year it's a balloted election.
Right, exactly.
Okay.
Yep. Thank you for asking that. Some of these things, you word them backwards and upside down, and they still don't make any sense. In this context, the initial call for candidates has to go out at least 90 days before the close of nominations. You send out the reminder notice 7 to 30 days before the close of nominations. And both of those notices need to contain the specific verbiage. Pursuant to Civil Code Section 5103, if at the close of the time period for making nominations, there are the same number or fewer qualified candidates as there are board positions to be filled, then the Board of Directors may, after voting to do so, seat the qualified candidates by acclamation without balloting. Again, there's very specific requirements for all these notices regarding what they actually say. It's not just a matter of getting them out in time. It's a matter of making sure they have the right content. Don't be shy about asking questions. If at that point you've done everything right, you can in fact hold an election by acclamation. The final step is that the board convenes a meeting, posts notice of that meeting, specifies in the meeting who the candidates are and what's going to happen. And again, there's specific requirements for the notice of that meeting. And in that meeting, the sitting board deems that those candidates are now the board by acclamation. So you have to go through all those steps, but you can, if you plan it out right, hold an election by acclamation. Okay. I've talked about the idea of the secret ballot voting procedure. And I said back in the day, we used to come together in Clubhouse and raise our hands. We don't do that anymore. There's a lot of bells and whistles to making sure that the balloting process is anonymous and confidential. We use a double envelope system, meaning when you send out your ballot packets, you're sending out the ballot itself, an inner envelope, and an outer envelope. And again, all these things have to have the ballot in particular has to have specific information on them, explaining to members what on earth they're supposed to do with all these things. The idea is you fill out your ballot, you do not identify yourself, you the homeowner, fill out the ballot, do not identify yourself anywhere on the ballot, stick it in the inner envelope, which also doesn't have any identifying information. Then you stick that in the outer envelope and send it off. And the outer envelope has your identifying information on it, has in particular your name, your signature, your mailing address, and the address for the property that you own in the HOA. And I'm glitching on whether you actually need to have your mailing address, but you definitely need to have your property address within the HOA. Why are all those things important? Because on one hand, we want to make sure that the vote itself is confidential, it's anonymous, people can't tell how each other voted. But on the other hand, we need to be able to make sure that the people who are participating are actual members of the HOA. And aren't, voting more than once or anything along those lines. So the outer envelope provides all the identifying information. So you guys can confirm, or well, it's going to be the inspector of elections. The inspector of elections can confirm, okay, I've got my list of members. This person's information is on the envelope. They're actually a member of the HOA. Okay, that envelope is good. I'm going to put it in the stack that I'll count later on. That's why all that information is important, but it's also why we use this complicated double envelope system to keep things separated. We talked about the timing of the ballot mailing. We talked about not putting identifying information on the ballot itself and what the outer ballot must include. And just so you guys are aware, it used to be the case that management companies could be the inspector of elections for their own HOA. That changed. It used to be the case that we could be the inspector of elections for HOAs where we were general counsel. That changed. We do still provide both services. We can be general counsel. We can also be the inspector of elections. We just can't be both at the same time. But in that capacity, we're commonly dealing with things like, okay, this person filled out their name. They signed it, but they didn't include their property address. Which arguably invalidates the ballot. And we have to make a judgment call as the inspector of elections. Okay, we're going to put that aside and not tabulate it. All these things go to properly verifying that the process is working the way that it's supposed to. Okay, this is a bit of an artifact, the idea of proxies. Again, this is something that made more sense back when we didn't do votes by secret written ballot. The idea was, I'm not going to be around for our election tonight. I'm out of the country. I'm out of the state, whatever. I'm going to give somebody written permission to go to that membership vote and vote on my behalf. That's what a proxy is. When you live in a world where we're voting over a 30-day period through secret written mailed in ballots, proxies are a little less useful. They can still come up. The issues can still present themselves, but it's less common than it used to be. It's more of it's more antiquated. But the idea is written authorization to vote for someone else. I have authorization to go into a meeting and vote for Melanie. She has an authorization to go into a meeting and vote for me, something along those lines. Usually the place to start is whether that's even contemplated by the bylaws. If it's not contemplated by the bylaws, chances are it doesn't apply to that HOA. It's particularly important if you're talking about something where the bylaws require a membership vote on an issue, but the Davis-Sterling Act does not. It's not a matter of a special assessment or amending the governing documents or electing the board or exclusive use common area. It's something where the bylaws, but not the law, say we need a membership vote. That's where proxies might become more important because you're not necessarily beholden to this whole Davis-Sterling process that we've been talking about. As I said, proxies are these days largely impractical. They're not required under the Davis-Sterling Act since we're using secret written ballots. And that's the type of thing where if they're still in the bylaws and your HOA is ripe for amending the governing documents, that's a good opportunity to get rid of that because it's probably not doing anyone very much good and can raise needless confusion. Okay. The voting procedure, the election itself, must be in an open noticed meeting of the board or the members. We probably don't have time in this context to get into the whole virtual meeting conundrum, but the main thing to understand for right now is that you need to have, it can't be done in executive session. You need to have a properly noticed open session of the board or open session of the members where the inspector of elections is going to actually tabulate the votes and tell you the outcome. The approval requirement. I said at the beginning, we weren't just talking about board elections, and then I spent a lot of time talking about board elections. Let's take a step back. The approval requirement depends on what you're voting on, and it depends on what the bylaws have to say. For some things, like a special assessment, the law specifies what the voting requirement is. It has to be a majority of a quorum. At least 51% of the members have to vote, and a majority of those voting have to vote in favor of the special assessment. When you're talking about electing the board, it varies widely. It depends on the governing documents, what they say. Some governing documents have a quorum requirement for electing the board. A lot of governing documents don't, and say it's just the raw number of ballots that you receive. Whoever gets the most votes wins. Some bylaws seem to say that they have a quorum requirement for board elections, but if you look closely or get us involved, get council involved, it turns out that it's not exactly a requirement. And that can be useful to know. A lot of times HOAs get stuck. There's actually a bill being considered by the legislature right now to try to fix this, that you guys know. A lot of times HOAs get stuck on that quorum requirement for a board election, and they can't get the right number of ballots to start counting the ballots and can't get the election done. Hopefully, the law on that point will change at the coming session, but it hasn't changed just yet, and we don't know whether it will. If you're in that particular position, get us involved, get council involved. Sometimes that quorum requirement in the bylaws doesn't necessarily apply to board elections. It depends on how it's worded. Amending the governing documents, amending the CC&Rs, amending the bylaws, that's another one where it varies widely. It depends on what the actual documents themselves say. If you have an HOA where the CC&Rs say you need a supermajority to approve an amendment, or the bylaws say that, that can become a little tricky. That's certainly something we, your council, can help you out with if you get stuck with that. So some sample language. Sometimes the governing documents will say at least 51% of the members must approve the amendments to the CC&Rs and the bylaws. And then the actual ballot will say something like owners of at least 161 of the 315 units must vote approve. That's another thing to understand about the ballot itself. I keep saying there's a lot of technical requirements for what the notices have to say, what the ballot says, what happens on the envelope. And that's a critical piece. The ballot itself has to specify if we're talking about member approval of a measure, special assessment, governing documents, you need to specify how many votes does it take for this to actually pass? Is it a majority of a quorum? If so, how many is a quorum? And we see issues all the time where determining what a quorum actually is for this particular vote in this particular HOA can be very complicated. Get our help, get council involved. Okay. So you've gone through this whole process. You have the actual membership vote. The inspector of elections has tabulated the results and in the meeting has said, okay, here's the outcome. Three basic things that need to happen. One, the inspector of elections is to promptly report the outcome to the board. Usually that just happens in the meeting. The inspector is sitting there, counts up all the votes and says, okay, I have the outcome now and here it is. The next thing that needs to happen is that that outcome is recorded in the meeting minutes for the next regular board meeting. And the third thing that needs to happen is that general notice is given to members within 15 days of the tabulation. General notice means you don't necessarily need to mail that out to everybody individually. You can post it in a prominent designated location within the HOA, depending on what your annual policy statement said. I said at the beginning, if you've got somebody in the HOA with an axe to grind, they're not happy with the board, they're not happy with management, they're not happy with us, and they're trolling for an issue, this is a great way to bring legal challenges. There's all kinds of, as hopefully you're getting from the presentation, there's all kinds of potential for technical violations, and we know there are people out there looking for technical violations so that they can seize upon them and challenge them in court. Some basic ones are whether or not there are proper election rules in place, or whether or not those election rules were properly followed. Did the process go along with the right procedure? Have there been campaign violations? I've got a situation right now where in the middle of everything, a sitting member of the board went on a community messaging board that wasn't HOA media and voiced his views on who he thought should be elected. And now the people that lost the election are saying that they lost it because he took that position, and arguing that he basically went out and lobbied other members of the HOA to say, don't vote for these people. And the argument ends up being, okay, he wasn't using HOA media. Is he exercising his free speech? But it's exactly the type of thing that can cause a lot of confusion. And a lot of things, it's exactly the type of thing that can lead to legal challenges. These are the sorts of things to be mindful of. Because the statute of limitations for a legal challenge to any given membership vote is 1 year, the inspector of elections has to retain not only the ballots, but all the documents related to that election for 1 year. And any member at any time can say, I want to inspect those records. There's some steps we need to go through to make sure that's done properly. They're not permitted to take copies or to make copies of records, but they are entitled to inspect them. The Inspector of Elections holds those documents, retains them for a year, and if there is a request for a recount, the Inspector of Elections has to still preserve the confidentiality of those votes. So for example, when I'm the Inspector of Elections, I'll go through a whole thing of, I take the outer envelope, I put it over here. I take the inner envelope, I put it over here. I take the ballots, I put them over here. That way I don't know what ballot came from what envelope, came from what envelope. I know the count is right. I know that I have an envelope from everybody that came in the first place. I know I have the right number of inner envelopes and the right number of ballots, but nobody looking at those documents is going to be able to tell how any one person voted. At the end of that 1 year, when somebody could bring a legal challenge, those documents revert from the Inspector of Elections back to the HOA, and the HOA retains them from that point. The reason this is sort of a good way to bring a challenge to the HOA is any homeowner can do it. There's a 1 year time limit, and if they don't like the outcome of the membership vote and they prevail, the court can order that the results of the election are voided, and the HOA has to do the whole thing over again. There's also the potential for monetary penalties, up to $500 per violation. The homeowner can also recover reasonable attorney's fees. They can recover court costs. And here's the kicker. Even if the HOA prevails, the way the law is worded, the HOA cannot recover its costs unless the claim by the homeowner is just ridiculously crazy and stupid and the court can't even stand it. Usually that's not going to be the case. So even having to weather that challenge, don't think in terms of, well, we're going to win and get back the attorney's fees and get back the court costs. Even if the HOA wins, they're going to be out of pocket on all those costs. When you get challenges along these lines, get counsel involved, get us involved, get the Inspector of Elections involved. I've had situations where the issue is being brought to me and I'm having to say, technically it needs to go to it's being brought to me as the general counsel. And I'm saying, technically it needs to go to the Inspector of Elections first. Now, the reality is that a lot of times the Inspector of Elections will punt the issue back to me, but the Inspector of Elections is supposed to play that initial role of reviewing challenges, facilitating review of the documents, and making sort of an initial determination, is there a potential problem here? They were the ones handling the election. They're in the best position to say things did or did not go the way the person challenging them is saying they did. But anytime you get a challenge along these lines, get us involved, get counsel involved, make sure the Inspector of Elections is aware so we can make sure it's being responded to properly and tell you guys what the potential issues are. Common errors. As I said at the beginning, this is an area where it's rife with possibilities for technical errors. You've got a number of notices that not only have to go out at a particular time, they have to say specific things. It's easy to have a misstep. You have non-compliant notices, you have non-compliant ballots. You can have issues where the wrong counting was applied. I just had a big issue where we haven't done the membership vote yet, but there's an extreme amount of controversy over what number actually applies. It's not one of the types of membership votes we're talking about. It's something a little bit more complicated involving whether the builder gets to cast a vote. But figuring out what quorum is, what the right number of households is to reach quorum, what the right number of households is to reach a majority can be deceptively complicated. And that's something where you can step into errors without realizing it. Using proxies in elections where you're supposed to be using a secret written ballot. We talked about wrong quorum requirements. Having management act as the Inspector of Elections. That's something that was a really convenient thing to do in years past that the legislature has said, you know, HOAs, your lives are a little too easy. Let's make that more complicated for you. Improper counting of the ballots. Misinterpreting, outdating, or confusing bylaws. This is a good reminder that if your governing documents are 5, 10, 20, 30, 40 years old, they really need to be amended. A lot of the issues we see come up because they're worded really badly. The governing documents are ancient. They don't make much sense. They have nothing to do with what Davis Sterling currently says, and they're creating needless confusion. They're creating needless dissension, and somebody's saying, hey, wait, the bylaws say this, and now I'm going to bring my legal challenge. make sure you're working with your boards to have council look at updating the governing documents. And of course, not having proper election rules in place following SB 323. Okay, I do not intend to read to you guys the entirety of these provisions, but this gives you a sense, for those of you who haven't seen these things already, of the level of complexity of the law. This is the portion, section 5110, regarding inspector of elections and their role. Here we've got a bit of the process and the information that needs to go on the outer envelope in the double envelope system. We've got who can be the inspector of elections, no person including, I'm sorry, got who can be the inspector of elections, and also who has access to the documents. Part of the legislature's intent in saying we don't want the inspector of elections to be the manager or the attorney is to avoid potential conflicts of interest. Now, it can still be a homeowner. The problem there, of course, is that homeowners are professionals and are maybe more likely to step into errors. And we've got the portion regarding all the different election materials that have to be retained by the inspector of elections for a year afterwards: the sealed ballots, the signed voter envelopes, the voter list, the proxies, the candidate registration list. All those things have to be retained by the inspector of elections. And this is the portion regarding elections by acclamation and all the requirements for that. Okay. I feel like I blazed through that presentation very quickly, and maybe I'm even speaking more quickly than I usually do. Questions, comments, concerns, things you guys are struggling with, things that don't make a lot of sense, things that seem impractical. And I can't tell if I can. Roman, if you see somebody raising their hand and I'm not seeing it, let me know.
Yeah, I'll raise a hand too. So regarding that, the acclamation section again, about those changes that were made. You know what? I take that back. I don't have a question about that. I understood that. The
really? Because I didn't.
I'm going to go back and rewatch that particular section. Never mind. I retract my.
So Lance, if you stop sharing screen, you'll be able to see all the attendees better too.
Perfect. Thank you very much.
You're welcome. Don't be shy, guys. If you have a question, now's the time.
I explained it too well, is what I did, and everybody knows everything now. Nicole, what you got? Nicole, I can't see you. You just look like you're just a tree there.
Okay, you can see me. I have a question kind of about elections by acclamation. So what if we start the process with intending to have candidates put in their call for candidates and we do it in a timely fashion and then we don't get enough? Can we then make that determination?
That's a great question. Thank you for asking that. So I want to make sure everybody caught that. The question is, what if we start the election process and then realize we don't have enough candidates? Can we then just decide to do an election by acclamation? And the short answer is not really, no. You want to make sure, and that's why I say approach it from this, think of board elections as though they're going to take up half of every year. Because what the legislature has now told us is we need 3 months for a call for candidates period in order to tell everybody that that acclamation is a possibility, and then do the election by acclamation. If you haven't gone through all those proper steps and you just send out the regular 30-day call for candidates and the 30-day ballots and wait, we don't have enough candidates, technically you're stuck. Now, it does come up a lot. Now, we get questions, hey, Lance, I did it this way, I kind of did this, I kind of did that. And we say, okay, let's figure out ways of fixing that. I have one right now where what happened? The call for candidates went out 90 days in advance. The reminder didn't happen exactly when it should have. And so the practical solution there ends up being, let's extend the nomination period so that members are getting that 7 to 30 days reminder notice before the end of the nomination period. And then we've fixed that potential procedural defect in doing the election by acclamation, and we can keep on from there. So when you find a misstep, there's often going to be a way of fixing it. Just talk to us or talk to council, but understand going into it that you really need to, you really got to sit down with each HOA's bylaws, figure out when their elections are supposed to be happening, and count backwards 7 months and give yourself that buffer time to figure out when all these notices need to go out. And like I say, call us, call council with questions, because it's a very complicated procedure that wasn't so complicated even just a few years ago. I hope that helps.
Yeah, that's grateful and great. And then we also, just to kind of piggyback on that, we have in our annual financial review that we send out in April, a little tagline about election by acclamation. And then we also have the statement on our call for candidates. And we track elections internally. Liz, who's on the call, is actually our election tracking person for the company. So it sounds like, based on our information that we've received today, the only thing that we would need to, I guess, maybe more formalize is that reminder notice. And along those lines, is there specific language required in that reminder notice that's sent out 7 to 30 days before the deadline for candidate submittal? There
is. It's the language that I had on the one slide. That's for both the call for candidates itself and for the reminder notice. And I can give you the slide number here in a second. So
and can I get a copy of the whole presentation so we can share that with the team? Sure. Just don't disseminate it, and understand, like I say, particularly with elections, the law changed hugely in 2020, changed again in 22. These things change all the time. Please don't rely on outdated information. Assume come December 31st, 2023, anything I said today is null and void. Yeah, because the procedure we put together does need to be updated with the new language from 2022. Absolutely. Yeah, I'll send that over to you. And I'm looking at the slide. I can't tell what slide it is. Let's say it was slide 8, the one entitled "Elections via Acclamation." Okay, awesome. But yeah, I was wondering what protocol you guys had in place, because I imagined you had something pretty well teed up for it. And yeah, when mistakes happen, give us a call. It happens all the time that people are saying, we did this part right, but not this part right. What do we do now? And of course, we're happy to help when that comes up. Excellent. Other questions, comments, concerns, general musings? Brad looks like he has a funny joke on his mind, but not actually a question. He's always laughing about something, huh? He's a funny guy. I'm trying to think if there's anything else that I could throw out there.
Can you?
Yeah, and I guess that.
Oh, I'm sorry.
Okay.
Can you repeat the thing about the 3 years and the 4 years slide again, just to reiterate that thing? It was a ballot election every. What was the 4 years? Now I'm confusing the numbers.
Well, and it's one of those things where the statute itself is a little confusing. There's 2 requirements. One is that you have to hold an election for each seat on the board at least once every 4 years. Okay, that's requirement number 1. Separately, if you're going to do an election by acclamation, you have to have held an election of the directors by membership vote in the last 3 years. Those 2 provisions don't quite match up perfectly, but they effectively do. I would say, if you haven't held a membership vote for the board, this is 2023. If you didn't do one in 22, 21, or 20, don't do an election by acclamation.
I see. So does for that 4 years of each seat, if that seat is specifically reclaimed by acclamation, does that work with that, and that is okay, or is that separate and needs to be balloted? It's a good question, and we see all kinds of combinations of facts all the time. So I'm trying to think it through. If you have a seat where there was an election for that, well, I take that back.
To
Hey,
do an election
Lance.
by, yes, sir.
To answer the question, difference between 3 and 4. The 4 is, correct me if I'm wrong, but basically a seat can't be held for more than 4 years at a time.
Correct. Correct.
So how some HOAs have longer than 1 year terms for their seat, it just can't be more than 4 years. So if you had some officers on a 4 year term here and some officers on a 4 year term here, as long as they weren't all sequential, as they, so every 2 years you're having an election for some of the officers, that would be okay.
Sort of. So, and I appreciate you helping me trying to differentiate it. So with acclamation, the idea is, have we held a membership vote for the board in the past 3 years? If we haven't, then we need to hold a membership vote for the board. Separately, each seat has to be up for election at least every 4 years. So think of it this way. Anytime you're sitting down to figure out, okay, who's up for election this year, you're thinking about a few different factors. You're thinking about, as Brad says, the length of terms for each seat. You're thinking about how recently those seats were up for election. You're also thinking about, okay, that seat has 2 year terms, and we did an election 2 years ago, and didn't do one 2 years before that. We need to have an election now. I think I said that right. But the broader takeaway is this: we see all kinds of combinations of facts, and we constantly see HOAs where folks don't know how long so-and-so has been sitting on the board. The board members don't know how long they've been sitting on the board or when their term actually started. You guys don't know, we don't know. And sometimes we have to reconstruct over a period of a few years what actually happened. Usually what you end up needing to do, though, if you realize things are off track, you want to work with council or work with our office. But usually what we're talking about is, oops, somebody's been in their seat for too long, or we didn't hold the election when we were supposed to, and we need to fix that. And fixing it usually means, in order to get things back on track, we're going to have to let one of those violations stick while we fix the other one. We're going to go ahead and shorten this person's term so we can hold an election and get back on track that way, or we're going to let this person have a longer term and push out the election so we can get back on track that way. It's always a balance with the 5 or 6 different variables and figuring out what's going on with this HOA. How do we comply with these things under the Davis-Sterling Act? How do we comply under the bylaws? We're off track. How do we fix it? We talked about a few different scenarios in that. I hope that was helpful. I think the big thing is when you're dealing with questions along these lines, get council involved, get us involved so we can look at the whole picture and line up the facts you have, who's on the board now, what seats, with your governing documents and with the law. If I talk more, I can probably make it more confusing. Other questions, comments, thoughts? Who's a big fan of elections? Okay. I guess the other thing I'll say is this, and I said it a few different ways, but err on the side of getting input at the beginning. It sounds like you guys have a good structure in place to help you through with the way Paul handles things for elections, but err on the side of getting input before you got the door. We have a flat fee package where the whole idea is, let's just hold your hand through this election process. We're not the inspector of elections. We're just helping you figure out what needs to happen here. But it's easier on everyone, including you guys and the board and the HOA members, to map out what needs to happen ahead of time, come up with a plan to make sure everything is done right, then to, at the end of the day, realize somebody's alleging some technical defect, and now Lance has to twist himself into a lawyer pretzel trying to figure out how to argue around that defect and keep the HOA out of court. We're happy to do it when it comes up. We're happy to help you guys out, but it's easier to deal with things on the front end, help you guys come up with a map and a timeline for what needs to happen with this particular membership vote. Other thoughts? Okay.
Thank you so much for your time today, Lance.
Thank you, Lance.
Absolutely. Thanks for having us, guys. Always good to see you. And I think I'll be seeing you again in a week or so. But have a good weekend.
All right. Thank you.
Thanks.
Bye.
Bye.
Bye.